If you're holding two passports right now, or you're thinking about getting dual citizenship, I need you to stop what you're doing and pay very close attention to what I'm about to tell you. January 2026 is about to bring a massive earthquake to U.S. dual citizenship policy. We're talking about changes so significant they could completely transform your rights, your tax obligations, and even how your American citizenship is legally viewed. And I'm not exaggerating when I say this could affect millions of Americans living abroad and those of you who maintain strong ties to your countries of origin. Here's what makes this urgent. By the time you finish watching this video, you'll know exactly what's coming your way, why it matters to you personally, and most importantly, the exact steps you need to take right now to protect yourself. So I need you to stay with me until the very end, because missing this information could end up costing you more than you can imagine. Hey everyone, John here, and welcome back to Dream Visa Updates. This channel exists for one reason: to break down the most critical immigration and citizenship news that directly impacts your life. If this is your first time here, let me tell you what we do. We cut through all the legal jargon, all the confusion, and we give you clear, actionable information that you can actually use to make smart decisions about your future. Now, today's topic is extremely time-sensitive. We're going deep into the sweeping changes to dual citizenship regulations that the U.S. government is rolling out starting January 2026. And when I say sweeping, I mean fundamental shifts in how America views and manages dual nationality. We're talking about changes that touch everything: your tax responsibilities, your passport, renewal process, your voting rights, your ability to work in federal service. Everything. Whether you were born with dual citizenship, you got it through naturalization, or you're seriously thinking about getting citizenship in another country, this video is absolutely essential for you. I'm going to walk you through every single major change, explain what it actually means in plain English that anyone can understand, and then give you concrete action steps to prepare yourself. So do me a favor right now. Hit that subscribe button and turn on those notifications so you never miss critical updates like this one. Trust me, as these changes start rolling out, you're going to want to stay informed every step of the way. Let me give you some essential background context here. For decades, the United States has had what I'd call a complicated, almost contradictory relationship with dual citizenship. Here's what makes it interesting. The U.S. government doesn't actively encourage or promote the idea of holding citizenship in multiple countries. In fact, if you look at the official government position, there's a very clear preference for Americans to have single allegiance to the United States alone. But here's where it gets fascinating. The reality on the ground has been completely different. The U.S. has quietly tolerated and effectively recognized dual nationality under specific circumstances. This has created a practical framework that millions of Americans have lived within for years, building their entire lives around it. Think about what happens at a naturalization ceremony. When people become U.S. citizens through naturalization, they stand before an official and take an oath. That oath includes very specific language about renouncing allegiance to any foreign prince, potentate, state, or sovereignty. Sounds pretty absolute, right? The words are crystal clear. You're literally declaring that your loyalty now belongs exclusively to the United States of America. But here's where theory and practice split apart dramatically. Despite that solemn oath, the U.S. government has never actually required people to physically hand over their foreign passports or go through a formal process to renounce their other citizenships. Many naturalized Americans have continued holding their original passports, traveling on them, and maintaining full citizenship rights in their birth countries, all without facing any consequences or penalties from U.S. authorities whatsoever. The same flexibility has applied to people born with dual citizenship. Picture this scenario. A child is born in the United States to one American parent and one parent who's a citizen of another country. That child often automatically receives citizenship from both nations the moment they're born. For decades, these individuals have been able to keep both passports, enjoy rights and privileges in both countries, access education systems in either nation, work in both places, and essentially live with one foot planted in two different worlds, all without encountering any serious legal obstacles or government interference. This practical tolerance has created a huge population of dual citizens. We're talking about millions of Americans who have built their entire lives, their careers, their family structures, their financial plans, all around the assumption that this flexibility would continue forever. Many have bought property abroad, started businesses in their countries of origin, opened bank accounts in multiple countries, and created these complex international lives that literally span continents. But as we get closer to January 2026, that entire landscape is about to change in a dramatic way. The era of relative flexibility and hands-off oversight is coming to an end. The U.S. government has announced a comprehensive overhaul of its dual citizenship policies. They're implementing stricter regulations, enhanced monitoring systems, and significantly more aggressive enforcement mechanisms than we've ever seen before. So what's actually driving this massive policy shift? The government has outlined several key reasons behind it. First, and most important, is national security. In today's increasingly complex geopolitical environment, with rising tensions between major world powers and growing concerns about foreign influence operations, the government wants much greater clarity about where dual citizens' loyalties actually lie. There's serious concern about potential conflicts of interest, especially when dual citizens work in sensitive government positions or have access to classified information. Second, there's the whole issue of tax compliance. The United States has one of the most aggressive tax systems in the entire world when it comes to taxing its citizens who live abroad. America taxes based on citizenship, not where you actually live, which makes it almost unique among nations. This means that if you're a U.S. citizen living in Tokyo, London, Dubai, or literally anywhere else on this planet, you're still required to file U.S. tax returns and potentially pay U.S. taxes on your worldwide income, no matter where that income comes from. The government believes that dual citizenship has created too many opportunities for tax avoidance, with some individuals strategically using their multiple nationalities to hide income, conceal assets, or exploit loopholes in international tax treaties. Third, there's a major push for greater international transparency and cooperation between governments. The U.S. wants to strengthen its ability to track cross-border financial flows, fight money laundering, prevent terrorist financing, and make sure that American citizens aren't using their dual status to get around laws or regulations. This aligns perfectly with broader global initiatives around financial transparency and information sharing between countries. Now let's dive into the specific changes that are coming in January 2026. I'm going to start with what's probably going to hit dual citizens hardest in their everyday lives: taxation and financial reporting requirements. The United States already has what many people consider to be one of the most demanding tax systems for citizens living abroad. Through FATCA, which stands for the Foreign Account Tax Compliance Act, and various other regulations, Americans overseas must report their foreign bank accounts, disclose foreign assets above certain dollar amounts, and navigate this incredibly complex maze of forms and filing requirements. Many dual citizens have found this burdensome but manageable, usually with help from specialized tax professionals who understand both U.S. law and the tax systems of other countries. Starting in January 2026, the IRS is dramatically ramping up these requirements. The new regulations will demand much more detailed disclosure of your foreign assets. We're not just talking about bank accounts anymore. This enhanced reporting will cover foreign investments of all types, including stocks, bonds, mutual funds, and retirement accounts you hold abroad. It extends to real estate holdings, requiring detailed information about any properties you own in other countries, including rental income you receive, current property values, and any mortgages or financing arrangements you have. Your business interests will come under much greater scrutiny, with dual citizens needing to provide comprehensive information about any foreign companies you own, partially own, or have significant control over. The threshold amounts that trigger reporting requirements are being lowered across many categories, which means more people are going to get caught in this reporting net. The forms themselves are being completely revised to request much more granular information, including where the money came from that you used to buy foreign assets, who the beneficial owners are of any foreign trusts or foundations, and detailed transaction histories for any significant movements of assets. But here's where it gets really serious. The penalties for non-compliance or incomplete reporting are being substantially increased. Previously, if you made an honest mistake or overlooked something on your foreign asset reporting, the penalties, while significant, were often negotiable, especially if you were a first-time offender who could show you were genuinely trying to comply. Under this new system, the IRS will have much less room for discretion. Automatic penalties will kick in for missing information. Even technical violations could trigger massive fines, and the burden of proof shifts more heavily onto you as the taxpayer to prove that any omission was unintentional. The IRS is also getting enhanced tools for enforcement. Through expanded international cooperation agreements, the agency will have much better access to foreign financial data. Banks all around the world are increasingly required to report information about American account holders directly to the U.S. government. This means the IRS will often know about your foreign accounts before you even report them, and any differences between what you disclose and what they already know from these banks can immediately trigger red flags and investigations. For dual citizens, this creates a completely new reality. You absolutely cannot afford to be casual or approximate anymore in your tax reporting. Every single foreign account, every overseas investment, every piece of foreign real estate needs to be meticulously documented and accurately reported. The days of hoping that the IRS won't find out about your bank account back in your home country, or that small apartment you inherited from your parents, those days are essentially over. This also has major implications for how you plan your taxes and make financial decisions. Dual citizens will need to think much more carefully about where you hold your assets, how you structure your investments, and what the tax consequences are of financial decisions in both countries. What might be a perfectly tax-efficient strategy in one country could create absolutely massive headaches with the IRS, and vice versa. This is exactly why getting professional advice from tax specialists who deeply understand both systems becomes not just helpful, but absolutely essential for your financial survival. Let me move on to another major area of change: passports and documentation requirements. The U.S. State Department, which oversees passport issuance and management, is implementing enhanced verification protocols that specifically target dual citizens. Currently, when you apply for or renew a U.S. passport, the process is relatively straightforward. If you already have a previous passport or clear documentation proving your citizenship, you submit your application, provide the required photos and documents, pay the fee, and in most cases, you get your new passport without much additional scrutiny. That's changing in a big way. Starting in January 2026, dual citizens will face much more comprehensive documentation requirements when dealing with passport applications or renewals. The State Department will require much more extensive proof of your ongoing ties to the United States and where you actually live. This might include multiple years of tax returns proving that you've been filing as required. They may ask for proof of U.S. residence, even if you currently live abroad, such as property ownership records, utility bills, or rental agreements showing you maintain a home base in America, employment records showing you work for U.S. companies, or evidence of ongoing economic ties to the United States could be requested from you. There's particular focus on individuals who hold passports from countries that the U.S. government considers high risk, or countries with which the United States has strained diplomatic relations. If your second citizenship is from a country that's on any U.S. watch list, has limited diplomatic ties with America, or is seen as potentially adversarial to U.S. interests, expect serious additional scrutiny. You may be asked to provide extensive documentation proving your genuine connection to the United States and demonstrating that your primary allegiance remains with America despite holding another passport. The application process itself will likely take much longer for dual citizens. Where a typical passport renewal might take just a few weeks, dual citizens should plan for several months, especially if you get flagged for additional review. This has real practical implications for your life. If you need to travel and your passport is getting close to expiring, you absolutely cannot wait until the last minute anymore. You need to plan well in advance and leave yourself substantial buffer time for processing. Now let's talk about something that hits at the very heart of what citizenship means: the oath of allegiance. For those who become U.S. citizens through naturalization, the naturalization ceremony is one of the most profound moments of your life. You're welcomed into the American family, granted all the rights and responsibilities of citizenship, and you take an oath committing yourself to your new country. The government is revising both the language and the interpretation of this oath. The updated version will place even stronger emphasis on exclusive loyalty to the United States. Now, this is nuanced, so let me be very clear about what this actually means and what it doesn't mean. The revised oath does not automatically require you to physically surrender your other citizenship or go through a formal renunciation process with your other country's government. That would be extremely controversial and would face massive legal challenges. What it does is create much stronger legal grounds for the expectation that your primary allegiance, your ultimate loyalty, must rest with the United States. In practical terms, here's what this means. If conflicts arise between U.S. interests and the interests of your other country of citizenship, you are expected to prioritize American interests every time. If your actions are seen as actively supporting a foreign government in ways that oppose U.S. policy or threaten U.S. security interests, those actions could now trigger a formal review of your citizenship status. This is extremely serious. We're talking about potential denaturalization proceedings in extreme cases, where the government could theoretically move to revoke your U.S. citizenship if they believe you violated the fundamental principles of that allegiance oath. Now, this doesn't mean you can't visit your country of origin, maintain your cultural connections, or even advocate for policy positions that might benefit that country. What it means is that there are now clearer red lines about activities that would be considered totally inconsistent with your oath of allegiance. Things like working for a foreign intelligence service, taking a position in a foreign government that involves creating policy in opposition to the United States, or engaging in activities that could be interpreted as supporting foreign interests against American interests. All of these would potentially trigger serious scrutiny and investigation. For individuals who were born with dual citizenship, you never took a naturalization oath, so these specific changes don't apply to you in exactly the same way. However, you're definitely not exempt from increased oversight. The new regulations introduce additional background check requirements for dual citizens who are seeking positions in sensitive sectors. If you're applying for federal employment, especially in agencies dealing with national security, defense, intelligence, law enforcement, or diplomatic services, expect much more rigorous vetting than ever before. These background checks will go much deeper into your connections with your other country of citizenship. Investigators will examine your travel patterns closely. Do you spend significant amounts of time in your other country? They'll look at your financial ties. Do you have substantial assets, business interests, or sources of income there? They'll review your family relationships in detail. Do you have immediate family members who work for that country's government or military? They'll assess your communication patterns and social connections. Being a dual citizen won't automatically disqualify you from these positions, but it definitely adds a significant layer of complexity to the entire vetting process. You'll need to be completely transparent about all of your foreign connections, prepared to answer extremely detailed questions about your loyalty and allegiance, and possibly willing to accept certain restrictions on your activities or where you can travel as a condition of getting employment in these sensitive roles. The Department of Defense is taking this particularly seriously when it comes to military service. Dual citizens have served honorably in the U.S. Armed Forces for many years, bringing diverse perspectives, valuable language skills, and cultural knowledge that genuinely enhance military capabilities. However, the Pentagon is now re-examining its policies regarding where and how dual citizens can actually serve. New rules being implemented may restrict the deployment of dual citizens to certain geographic regions, particularly if their secondary nationality is from a country with adversarial or strained relations with the United States. Imagine you're a dual US-Iranian citizen serving in the military. Under these new policies, you might be restricted from deployments to the Middle East or from positions that involve classified intelligence related to Iran. Similarly, a dual US-Russian citizen might face limitations on European deployments or assignments that involve NATO operations. These restrictions aren't meant to question anyone's patriotism or their dedication to service. They're driven by legitimate security concerns about potential conflicts of interest, the risk that you could be coerced if you have family living in your other country of citizenship, and the complications that could arise if you were captured or detained while serving in a region connected to your other nationality. For service members who maintain dual citizenship, this could have significant implications for your military career. Certain career paths, especially those involving special operations, intelligence work, or assignments in sensitive geographic regions, might become limited or might be completely closed off to you. This is something that current service members and those of you considering military service need to very carefully evaluate as these new policies take effect over the coming months. Another area that's evolving, and this one is still somewhat uncertain, involves political participation and eligibility for public office. Let me be very clear up front. Dual citizens retain their fundamental constitutional right to vote in U.S. elections. That is not changing. Your ability to cast your ballot in federal, state, and local elections remains fully protected regardless of your dual citizenship status. However, there's growing debate, particularly at the state level, about whether dual citizens should be eligible for certain public offices or advisory positions. Some states are actively exploring legislative proposals that would restrict dual citizens from serving in specific roles, particularly those involving security clearances, access to classified information, or significant policy-making authority related to national security or foreign relations. These are not federal rules yet, and it's very unclear whether such state-level restrictions would actually survive legal challenges if they were passed. There are serious constitutional questions about whether individual states can impose additional citizenship requirements beyond what federal law already establishes. But the very fact that these conversations are happening at all reflects a genuinely changing political climate around dual citizenship and growing public discourse about potential conflicts of interest. At the federal level, while there are no outright bans being proposed right now, there is increased scrutiny of dual citizens seeking appointments to certain government positions. Presidential appointees with dual citizenship can expect much more intensive vetting, much more detailed questioning during confirmation hearings if Senate confirmation is required, and potentially more public debate about their suitability for roles that involve foreign policy, intelligence oversight, or national security decision-making. So given all of these major changes coming your way, what should you actually do to prepare yourself? Let me give you a comprehensive action plan that you can start implementing right now. First, and most important, stay informed through official government channels. Immigration law and tax regulations are incredibly complex, and they're constantly evolving and changing. You absolutely cannot afford to rely on random social media posts, secondhand information from friends, or general advice that might not even apply to your specific personal situation. Go directly to the official sources for your information. The State Department's website provides authoritative, accurate information about passport and citizenship matters. The USCIS website is your primary resource for immigration-related questions. The IRS website, particularly the sections that deal with international taxpayers and FATCA compliance, will give you the most current information about your tax obligations. Sign up for email alerts from these agencies if they offer them. Follow their official social media accounts. Many of these agencies also issue regular bulletins or newsletters specifically designed for Americans living abroad. Make it a regular habit to check these sources, maybe once a month, so you're never caught off guard by new requirements or approaching deadlines. Second, and I cannot stress this enough, get professional help. If you currently have dual citizenship or you're seriously considering applying for citizenship in another country, You absolutely need to consult with qualified professionals who specialize in this incredibly complex area of law. On the immigration side, find an attorney who focuses specifically on citizenship matters and has direct experience dealing with dual nationality issues. Make absolutely sure they're properly licensed to practice immigration law and are in good standing with their state bar association. Check their credentials carefully, read reviews from past clients, and ideally get personal recommendations from others who've actually worked with them and had good experiences. On the tax side, you need a specialist in international taxation. Ideally, you want someone who's either a certified public accountant with specific international expertise or an enrolled agent who's authorized to practice before the IRS. Even better is finding someone who deeply understands the tax systems of both the United States and your other country of citizenship. These professionals can help you navigate the incredibly complex interaction between two completely different tax systems, identify potential problems before they become serious issues, and structure your financial affairs in ways that maintain full compliance while legally minimizing your overall tax burden. Yes, these professionals cost money. Good immigration attorneys and international tax specialists are definitely not cheap. But think of this as essential insurance for your financial future. The cost of getting proper professional advice is absolutely tiny compared to what you might end up paying in penalties, legal fees, or lost opportunities if you make mistakes trying to handle these complex matters yourself. One single significant error in your tax reporting could result in penalties that far exceed what you would have paid for proper professional guidance right from the start. Third, organize all of your documentation. I know this is tedious, unglamorous work, but it is absolutely critical for protecting yourself. Create a comprehensive file, either physical or digital with secure cloud backups, containing all of your important citizenship and immigration documents. This should include your U.S. passport, both current and any expired ones, your foreign passport, current and any previous ones you've held, your birth certificate, preferably an official certified copy with the raised seal, your naturalization certificate if you became a U.S. citizen through the naturalization process, any certificates of citizenship or consular reports of birth abroad, if those are relevant to your particular situation. On the tax front, maintain very organized records of all your tax returns for at least 7 years. That's longer than the IRS typically goes back when auditing, but it provides you with a crucial safety margin. Keep thorough documentation of all your foreign accounts, including monthly bank statements, investment account statements, and year-end summaries. Save detailed records of any foreign real estate you own, including original purchase documents, mortgage papers if you finance the property, rental income records if you rent it out, and property tax payment receipts. Document any foreign business interests with incorporation papers, ownership agreements, partnership documents, and annual financial statements. Also, and this is really important, maintain records that clearly demonstrate your ties to the United States. This might include evidence of U.S. property ownership, lease agreements if you rent a home in the U.S., utility bills showing U.S. residence, employment records from U.S. employers, evidence of U.S. bank accounts and other financial relationships in America, records of any professional licenses you hold in the United States, and really anything else that demonstrates your ongoing genuine connection to America.